my name is Mike Nelson. I'm the managing broker here at Excalibur Home Management, and I'm often getting questions regarding landlord tenant law, either from our staff, new hires, or often from property managers around the state. So I thought I would record some of these answers and I could refer them to these videos. One of the issues that we have to deal with as property managers and landlords has to do with tenancy at will. There are a lot of people, that, including real estate agents, that mistakenly believe that anytime a lease is going on a month-to-month basis that it became a tenancy at will, and that's not the case. That's covered under 44.7.6 under the Georgia Code, and under 44.7.6 what it says is where no time is specified for the termination of a tenancy, then the law construes it to be a tenancy at will. Well, very few leases are not going to have language that include once this lease expires, it will continue on a month-to-month basis with all of the other terms and conditions remaining the same. And there's a huge difference between the lease that has all of those other terms and conditions still in effect versus a tenancy at will. Under a tenancy at will, you don't have late fees, you don't have other penalties that you can enforce regarding the tenancy. Under a tenancy at will, the tenant only has to give a 30-day notice to vacate, but the landlord would have to give the tenant a 60-day notice to vacate. If you have a lease that requires either party to provide a 60-day notice to vacate, that lease would still be enforceable even though it might be running on a quote month-to-month basis. So understand the difference between a tenancy at will and a lease that happens to be rolling over on a month-to-month basis.